Routine.
You know, other people still have not.
Well, I'm slow then.
All right, everyone, I'm going to call the docket. When I call the docket, you need to stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. So we have Leon Small in federal custody. If there's a defense attorney who has access to the PACER system, if you could look that up and just let me know when he is. Oh, you're here for Leon.
Judge, yeah, I'm having my secretaries look that up now.
Awesome. Kinsey Smith, custody. Millie Reyes, custody. Angela Perez, Fatima Malara, custody. Natasha Manning, and probation on that one. We need an update from BTC.
Yes, sir.
Juliana Guzman, she's in custody.
Yes.
Malik Lampkin, thank you. Arturo Calvillo, thank you. Tomas Cantu, Michael Sanchez, custody. Shakira Lagara, Jeffrey Dollar, custody. Rogelio Ibarra, thank you. Brianna Lorraine Luna. All right, Deputy Mejia, that's my fault, because in my mind, I was thinking, everybody's here. It's going to go smoothly. Anthony Freeman, Jonathan Pomeratz, custody. Audrey Bash, custody. Cassandra Garza. Thank you. Ray Guthrie. Roland De La Garza, custody. Israel Gonzalez. Thank you. Jesse Diaz Jr. Arno Pena, custody. Aristed Brown is by Zoom. Jesse Martinez, custody. Lincoln Mertens, custody. Richard Esquivel. Thank you. Ruben Martinez, custody. Isabel Arias, custody. Valina Page. Colton Kasmerick, custody. Clarence Lacey. Roland De La Garza, custody. Andre Warrants.
President Council.
Thank you. Anthony Perales. Thank you. Thank you. Israel Gonzalez Jr. Sorry, you're on the docket twice. Gabriel Scott Pizzana. Adelia Sabs, custody. Manuel Ramirez, custody. Eddie Lee Dacey. Henry Renee Salazar. David Cortez Jimenez. Jenna Rodriguez, custody. Andre Xavier Crawford. Henry Renee Salazar. Martin Mendez, custody. Angel Varela, custody. Richard Cantu, custody. Michael Joseph Mora. Anijah Gifford. Vincent Munoz, custody. Enrique Soriano, custody. Again, Michael Joseph Mora. Thank you. Shelby Jean Rodriguez. Is she in custody?
First, it's in a motion for new trial on any dysfunction.
Okay, all right, thank you. Noah Nellum, custody.
Yeah, he's in Williamson County, there's a baby responding conflict.
All right, just give us a moment on that one. You signed in, correct?
Yes.
Irene Gonzalez.
Here.
Jesus Prado, that's at 1:30. All right, anyone who came in later, your name was not called? Yes, what is your name? Natasha Manning? Oh, I have you as, you're good.
Yes, right. We have an update for BTC for probation on that matter.
All right. All right, everyone. These are the rules of the court. Please follow these rules and the court will run smoothly. First off, we're recessing at 12. And Deputy Mejia, I really mean that this time. We are completing a jury trial. If your attorney is not here by 11:40, you're going to be recalled for tomorrow. So if you don't see your attorney, it's probably best if you call them on the phone and let them know we're recessing at 11:40. Don't come running in here at 11:45 and saying just one more thing, because it's not going to be able to happen. Attorneys, these are the rules. Please follow these rules. You are not ready to approach the court unless you confer with the state and confer with your client. For the people who have persons who are in federal custody, just make sure you have all the discovery from the state. So when your client is released from federal custody, we'll be prepared to proceed either with trial or some type of an agreement. If your client wishes to speak to the court in a language other than English, we'll need an interpreter, whether you speak the language or not. You need to take off your hat. The other thing is, for security reasons, there's a limited number of inmates that are allowed in the box. Once you request an inmate, do not leave. If you leave, you're being selfish to everybody else, because we won't be able to bring someone out because your person is taking up space. When we are on the record, do not talk behind the court reporter. If you are speaking to your client in the box, just raise your hand. The deputy will move you to the other end. How will you know we're on the record? Because I will have called the style of the case. Probation, could you raise your right hand? If you have a client who's on probation or seeking probation, you need to confer with probation. I'm going to ask their opinion anyway, and they're an integral part of the system. We're supposed to be going paperless. If for some reason the system shuts down or things are destroyed, who knows what's going to happen? But where we are now is we're going paperless. So what does that mean? That means when you're ready to approach the clerk, sign in and tell her the reason for your approaching. If it's a plea, let them know if it's a plea. If it's a motion to revoke, let them know it's a motion to revoke. If it's for sentencing, let them know, because I'll need to know. So I'll need to know what I need to look up on the system. Today is Monday. I know everybody's crunched for time because they're trying to make sure maybe Santa comes to their house. But this is where we are. People waited to the last minute again, which is what attorneys do. We procrastinate. Am I right, Adam?
You're always correct, Judge.
Oh, look at him. Merry Christmas. All right, everyone, please confer. Cindy, I made a mistake. I started off my day without putting my hands on the home road keys. And you know, when that happens, it may mean that your day is going to fall off.
Okay.
All right, who's ready? Okay, so we have on page 9, fifth one down, Anthony Perales.
Sorry, who?
Anthony Perales.
All right, Anthony Perales. Anthony Perales. Hello. All right, so counsel, you spoke to the court earlier and you said this was a PTD?
It is, Your Honor. We did apply. He was accepted. We have received the contract. I'm just asking for a little bit of time so that I can go into contract with them. But it's my understanding the intent is to sign that and go into the program.
All right, I need a PTD date, please.
Yes, I can do January 15th.
All right, once you sign the reset form, you excuse.
Thank
Thank
you.
you.
Just for, make sure I understand it, if we sign the contract prior to that date, do either of us appear on the 15th?
You will need to appear on the 15th if his case has not been dismissed through PTD.
Thank you, Your Honor.
All right, thank you.
Thank you so much.
Thank you. Who else is ready?
Have a seat.
Yeah, see,
Judge.
page 16, second one down. No, Nellum.
Noah Nellum. All right, Ms. Ferguson,
Yes, sir.
on this one, counsel, when was your client deemed to be incompetent?
Your Honor, I do believe he was found in Ashley Jones' record.
We're not on the record, but okay.
Just
I
kidding.
like the way you say that. though.
I do believe he was found incompetent in September or October, but he has since been found competent. And
Oh, he's been found competent?
Yes, Your Honor. My understanding is that he is being brought back here.
All right, then you all need to discourage,
We've been talking, Judge, and he's still not here, so
oh, no, have you all received all discovery?
no, I don't believe I have received him because I've never had any paperwork.
All right,
Your Honor, this is a MTR, so anything that I've received, I've uploaded to Veripic, which I believe.
all right, so
defense
if you'll
counsel-
check on that.
I will, Judge.
All right, Ms. Ferguson. Recall this for the second week in January.
January 12th.
All right, we're gonna see if your client is back. Ms. Ferguson, make sure he is back.
Yep.
And then after that, if you want to contest it here, we'll set it for contested.
Yes, ma'am. January 12th.
Yes. And do you know when he was found competent?
I do not, Your Honor. I do believe it was in November at some point.
Okay.
I don't know the exact date.
All right, and Norma, we need to start talking to magistrate's court when they find somebody. Have you already had your hearing to say that he's competent?
No, Your Honor.
All right, so we'll set it for January 26th. And then we still can't move until the magistrate's court formally find him competent.
And Your Honor, I do believe he did that process in Williamson County.
Okay, all
So I'll put that out there.
right, thank you.
Yes, Your Honor.
So.
So council, yeah, so it's still gonna be January 12th, but
Okay.
council, you'll need to get in touch with Williamson County to actually have the documentation or the order from there that he's been found competent, because otherwise we can't move forward unless the court has that order. All right, thank you.
Thank you, Your Honor.
You're welcome.
Next judge.
Yes, who's next?
Neil Small was MTR on page 14 and Terry's on page 1.
Oh, yeah, I don't need this one.
Okay.
Thank you. Leon Small, good morning.
He is set for a plea on February 12th, trial February 23rd, and I have.
Wait, February 12th?
February.
Plea.
Plea and February 23rd for trial. We have already signed discovery. We did that the last time.
All right, Ms. Ferguson, if you all are in jury trial, how long do you expect this to take?
Oh, I don't know, Judge.
Okay.
I don't know.
Who is the prosecutor on Leon Small?
Oh, I thought you were asking on this federal case.
No, here.
Here, I think it's charges. I would imagine more than.
All right, so Ms. Ferguson, set this sometime in April for jury trial and plea deadline date. And counsel, if he's not here, he's not here.
Thank you, Judge.
We'll reset it. And have you all done the acknowledgement of discovery?
We did, Judge.
All right, thank you.
Check.
All right, we'll see you on April 7th, counsel.
Well, I usually can't watch why I don't watch this for long. Yeah, like we're in agreement. Yeah. Urgent care.
Right if I'm over there. You signing it?
Okay, well, let me just file that.
Yeah. Today.
Because I mean, I need you ready, so. I'm on the way.
Okay, I just wanted to, we're here, we're in the vote. We release that.
Let me know when you're ready, we'll sign you. And make sure you do a start of appeal.
Yes.
Okay, thanks, thank you.
Have a good day, good.
All right, thank you, you too.
Judge, I have one more?
I'll let you know when I'm ready.
Okay.
Thank you. All right, I'm ready.
Page 5, third one down. Ray Guthrie. Okay, call.
Ray Guthrie. Ray Guthrie. Hello.
Sorry about that, Judge.
Oh, that's okay. All right, today is plea deadline date.
Judge, we had some discovery issues, so we were reset last week for some discovery that we were missing, I believe this week.
I'm still having a hard time getting confirmation whether the surveillance from the bank exists. I was emailing detective last week and we're waiting on the bank, so I was going to see if I could call the bank myself or send my investigator to inquire about the surveillance, but that's the only piece pending, if it exists.
And we do have an offer, Judge, we're just waiting on the pending discovery.
All right. Norma, recall this for the week of January 5th.
So the fifth is a Friday. I mean, I'm sorry, the fifth is a Monday. Monday? Is that-
Monday.
Okay.
Oh, she said the 8th.
Oh.
For a Monday if we could. It just makes it easier for work scheduling.
All right,
Good, Joe.
Norma, can you put this on the Monday?
Sure.
All right, we'll see you back on the Monday.
Thank you so much. Judge.
You're welcome.
Thank you.
What kind of setting was it?
It is going to be a jury trial or plea or something's going to happen at that day. All right, anyone else ready?
No one at this time. So
All right, thank you. Well, aren't they ready on Shelby Rodriguez?
no.
Are you all ready on Shelby Rodriguez?
I'm ready. Director.
Could I have the information on Shelby Rodriguez? That's a request.
Yeah.
I tell people to sign in, they don't sign in.
Good morning, how are you?
Good.
Let's see.
Where's the defendant stand? I'm just kidding. That'd be me.
Just 1 second.
Here.
Yes, it's here.
Right. Cindy, are you ready?
Yes.
Court is calling 2024 CR 09126. This is a motion. It's ex parte Shelby Rodriguez. Could I have parties announced, please?
I'm Attorney Keith Gross. I represent Anthony Rodriguez, Your Honor.
Amy Owen for Shelby Rodriguez.
James DeWiggins for the state.
All right, and Miss Rodriguez is not present. Do you waive her appearance?
Yes, Your Honor.
All right, so we're here. There was a jury trial that was held. The defendant was found not guilty. The defense requested an expunction. The court granted the request for the expunction. And then a motion was filed. I'm sorry, what is your name, sir?
Keith Gross, Your Honor.
By Attorney Gross, requesting that a motion for a new trial on the granting of the expunction. Is that correct?
Yes, Your Honor, we did that in addition to a plea and intervention.
Right. And then there is also, let me see. And the other motion I had for you, there was a request for attorney's fees. That is not a part of this, correct?
No.
Okay. All right, then the court will hear your argument, counsel.
Thank you, Your Honor. As the court knows that Ms. Shelby Rodriguez was found not guilty and acquitted. She filed through her attorney a request to have the records expunged. My client, he in his intervention in new trial, he didn't get notice of the expunction trial and petition. This court granted the expunction without my knowledge, my client's Anthony Rodriguez, his knowledge or participation. There is and has been an ongoing family custody dispute in the 73rd District Court under cause number 2023 CI 24233, in which custody of minor children are at issue before the court. During the course of the investigation and the prosecution of the criminal case, the police had gathered several records, including interviews with Shelby Rodriguez. They had taken pictures and statements from her.
Okay, and sorry to interrupt, but let's start here. Number one, you stated you didn't have notice. The first question for the court that needs to be answered is because this is a criminal court, that's a civil court. The first question was whether or not you were entitled to notice.
In the expunction proceeding is a civil proceeding. My client has a legitimate justiciable interest in the
Based
preservation.
upon what? Because according to the law, and if I'm incorrect on my understanding of the law, let me know. But according to the law, the only party on a civil side that can intervene and request notice of expunction or that an expunction not be granted is the state. Am I reading that incorrectly?
No, that is absolutely correct, Your Honor, and I would push back against him saying that it's a civil case. If it were not within the 30 days under the purview of this court, it would be a civil case. But that's why it was filed under the criminal case number in this case, because it's an acquittal expunction that falls under the authority of a criminal court.
All right. So first things first, does everyone agree that with regards to expunctions, if there is going to be an intervention or a request that an expunction not be granted, that's to come from the state?
That's my position.
I disagree, Your Honor, because
Well, let's pull out the code.
Your Honor, his motion is under 55A.302. And if you look at,
Just one moment.
sorry,
You say 55A
yes, 302,
point 302?
yes, sir.
All right, so here we are. Article on the Code of Criminal Procedure, Article 55A.302. Of course, there are certain reasons or legal reasons a state may ask that a acquittal not be granted. One is if there's another pending criminal case. So Attorney Owens, is there another pending criminal case against Ms. Rodriguez?
No, Your Honor.
So that falls. And it says, in the case of a person who is the subject of an expunction order or the basis of an acquittal, the court may provide in the expunction order that the law enforcement agency and the attorney representing the state retain records and files if, one, the records and files are necessary to conduct a subsequent investigation and prosecution of a person. So there's no other pending prosecution. Or two, the state establishes that the records and files are necessary for use in A, another criminal case that's out, or B, a civil case, including a civil suit or suit for possession or access to a child. So it says that the state has to establish this. Otherwise, what could happen is whenever there's an acquittal and somebody wants an expunction, anyone can come in and say, I don't want them to have an expunction. So according to my reading of the article, the state has to establish that the records and files are necessary for use in a civil case. State, have you established that the records and files are necessary for use in a civil case?
No, Your Honor, and we would only do that if we needed it for, say, CPS court, which we were going to go forward in a lower burden. But again, that would be something that we intended to do. We have no intention of doing so at this time.
Your Honor, the argument would be that Article 55A.302 does not preclude somebody else from doing it, meaning only the state can do it. It doesn't say that Mr. Rodriguez could not come forward and say, we have a legitimate interest in seeking this. Well, the evidence, we've got most of the state's exhibits, or not the state's exhibits, but the exhibits used from the criminal prosecution. But my client clearly has a justiciable interest in maintaining and having access to those exhibits for the civil litigation.
So your argument is that anyone who's involved in any civil case can intervene or is entitled to notice of an expunction, just anybody.
No, not anybody, but in the case, my case, it would be the spouse, where the spouse was an alleged victim of family violence, where there is an ongoing proceeding involving custody of the children. I don't think there's a dispute here that there's a civil case involving the husband and wife, involving Shelby Rodriguez and Anthony Rodriguez, that has to do with the custody of the children. And in this particular criminal case, it was alleged that she committed aggravated assault when she pointed a gun at his head and
She was found not guilty of that.
and I understand, but in this family matter, the level of proof isn't preponderant, isn't proof beyond a reasonable doubt. It's preponderance of the evidence, and it's still.
And are you seeking to terminate her parental rights in
No,
the?
Your Honor.
Okay, well, here's the thing. The code is the code. That's what we follow. And if the legislature wanted it to include the state and other parties, it needs to say the state and other parties may. It only says the state. Ms. Owen?
I join in the state's argument that she should be granted the expunction. I mean, it's just a backdoor way to sort of annihilate her in the divorce proceedings. And the other part of it is they requested police reports and body cams and all that stuff. So they already have everything the state's destroyed.
And I have a issue to address regarding that as well.
Yes.
Well, one of the things he's asking for relief for is for you to determine that the things they already have may be used in the custody proceedings. And for that, I'd like you to turn to 5503, where it says, when the order of expunction is final, the release, maintenance, dissemination, or use of the expunged records and files for any purpose is prohibited. But next one, it says, under subdivision 3 of this article, the person arrested may deny the occurrence of the arrest and the existence of the expunction. And when questioned, they only have to say that it's been expunged. And then an offense under this is a Class B misdemeanor. So to produce these records in any other way, once it's been expunction, would be a criminal offense.
And that's why we're here today, Your Honor. I believe there's more to that statute.
Just one moment, I'm sorry.
Yeah, I completed it. The other one in the Bible.
Thank you. All right.
Couple things.
Mhm.
I do remember reading where the dissemination of this material for money was a criminal offense. Nevertheless, the reason we're here is because, not because I need the state, the police agencies, or to preserve their records, because we've gathered almost 90 exhibits to be used in the civil case before.
But no, let's backtrack a little bit. Because when cases are expunged, they're expunged. And the defense's argument that it is a misdemeanor to still disseminate records, that's correct. That is why when they do the expunction, they ask that the person be removed, all police reports, the fact that they were placed on bond with the bondsman, that's removed. Whatever the defense attorney or the person who's requesting an expunction puts in their order, then those agencies have to remove from their databases any record that this even existed, that the offense even existed. So it's not just for specific purposes that you will be held liable criminally if you were to disseminate information. Once you received it and you are aware, and usually they send it out certified to different agencies, then it's expunged, it's removed.
My client wasn't served. We're not a party to that list of people that were served with the expunction. We did find out about it. I think opposing counsel had produced it to us, but we were not on a list. In addition, that would also support my argument that my client deserved notice and a hearing, because if the state or opposing counsel is going to seek to prohibit the use of these exhibits at our family trial, then obviously I think she has a legitimate.
But when you file expunctions and your request for expunction, it is not involving several parties. It's involving the person who's seeking the expunction. That's why it's ex parte, whatever it is. So when someone's seeking an expunction, and counsel, feel free to correct me if you think I'm misstating the law. But when someone seeks an expunction, it's because they've been acquitted either by a judge or a jury. They've been found not guilty. Now, according to the code, it says the state must establish that the records in the files are necessary for use in, and it says another criminal case. Both parties have said there's no other criminal case in existence, or a civil case, including a civil suit or suit for possession of or access to a child. But it's the state who must establish that. Separate parties or individual parties cannot.
If I could shed a little light on
Yes.
this situation, Your Honor. This comes up quite frequently. For instance, if there's a police officer accused of a crime, police officer goes to trial and then is acquitted. The records, the investigation, all the state's files are expunged and destroyed. However, when it goes to arbitration, if internal affairs spoke to him, the internal affairs investigator is allowed to remember his conversation. His client is allowed to remember the events of that night as his client sees it. You can't expunge memories. So all those people can be subpoenaed, but the state's record, the state's hard evidence, that is what cannot be disseminated and used. Does that make sense?
Yes.
And Your Honor, for example, there's videos taken from the police officers when they went into the house, interviewing Ms. Rodriguez, where she made certain statements, including being suicidal, admitting to pointing the gun at this person, and that evidence has been contradicted by her, and it would be subject used for impeachment purposes. Also, some of this evidence had already been used by, I think his name is Dr. Thies, when he did a family custody evaluation and a psychological evaluation. So now, if this court's ruling, which would, I don't know if the court intends to enter a subsequent ruling saying you can't use this in the family case. I don't know.
All right, this is what the court is saying to both parties. And I want everybody to understand me, hear me clearly, internalize what I'm saying. Number one, your client as an individual does not have a legal right to intervene into an expunction in a criminal case. Your client does not have standing in a criminal proceeding to establish that he should intervene. I'm just following the law. What you all do on the civil side and whether documents can be used on the civil side, that is completely up to the attorneys over there. What I'm telling everyone, she was found not guilty by a jury. The defense requested an expunction, which legally they are allowed to do because she's found not guilty. The court signed that expunction order. That expunction order will still stand. What you all take that expunction order to mean on the civil side, that is for attorneys to discuss on the civil side with that judge. My only ruling is she's found not guilty. I accepted the verdict from the jury. The defense filed a motion to expunge. I expunged it. Counsel, I understand why you would want this information, but the court is bound by the law, and the law says you're not entitled to it. The law states that the only person who can bring up or establish that records are necessary is the state. And if people want to change what the legislature has done, then you all need to write the legislature.
The last thing, Your Honor, that begs the question is, being that the state is aware of the family proceedings and there's no dispute that civil litigation has arose out of custody, why hasn't the state joined in the motion? I mean, is it just arbitrary and capricious? They say, no, we know what's going on, but we don't want to ask the court. It begs the question, why would the state take that position?
All right. So this is what I can tell both parties. And please internalize what I'm saying. Number one, if the state wants to intervene in your motion right now, it's too late. Time has expired. Number two, the only persons who are allowed to establish a record stating that this expunction should not take place and who can intervene is the state. And that's what the law says. That's what the code says. If the code said something differently, if it said, individuals who are in the middle of a custody dispute are entitled to intervene, then I would have already known about that. And I would have made different rulings, but that's not what the law says. So the motion or your petition for intervention, that's denied. We can go off the record. Whatever you all do on the civil side, as far as if there are some police reports out there, that's for you all to argue on the civil side and argue before that judge whether or not that should be allowed or whether that's a violation of the law. All right, is there anything else?
Thank
No,
you.
Your Honor.
All right, thank you
Thank
so
you, Honor.
much. Thank you.
I would be excused.
Yes.
Thank you.
Have a good day, Judge.
Oh, you too. But I didn't see a motion to write tonight on there.
Not safe circuit, I'm sorry.
All right, who's here on Arturo Calvillo? Hello. Are you still in jury trial? Let me give this to you. Sorry it took so long.
Technically, yes, but we're not starting until tomorrow.
Oh, okay. I take my sorry back. All right, thank you.
Appreciate it, Judge.
Who's here on Andre Crawford? All right, if you'll come forward. Yes, one moment.
Operator's on page 13, Judge.
All right. All right, so you all agreed on an amount. $3,700.
Yes, Your Honor. That's what the victim, there's a document in there that came from Target. Because this occurred at Target where he was employed. There's a document in there from Target where they, I guess, interviewed the defendant about the items he stole and he admitted to the amount specifically that's requested by the state.
All right, so when are you gonna pay for this?
I can pay payments over time, Your Honor.
So when you say you can pay for this over time, how much are you talking about per month?
A month, I can pay 500.
All right, so can you pay 500 per month, or are you just telling me what I want to hear?
No, yes, Your Honor, I can pay 500.
Do you have employment?
Yes, ma'am. Yes, Your Honor.
All right. All right, court is calling 2025 CR 003791 State versus Andrew Xavier Crawford. Can I have parties announced for the record?
Melissa Albin for the state.
Keith Engelke for Mr. Crawford.
And are you Mr. Crawford?
Yes, sir.
All right, you entered a plea of no contest on September 16th. And according to this, he was to pay $500 already. So has he paid $500?
No, ma'am, he's not been able to do that.
Why not?
I get paid for my employment tomorrow, and I was gonna have the money today, but why? Sometimes my check comes early, but it's not like always the same. Like, it's not always the same time, and I get paid tomorrow. I was gonna have.
State?
Yes, ma'am. He said that he would have the money today and, or by now, and he hasn't, so obviously that raises concerns.
All right, so here's the issue for the court. The issue is that this was set on September 16th. You entered a plea, and the court, you said you would pay $500 by the next setting.
Yes, sir.
So here we are in December.
Yes, sir.
So when are you gonna have the $500?
I can have it tomorrow. I can bring in money to.
All right, your bondsman did an affidavit to surrender surety. So what I'll do is I will, how are you paid?
Weekly.
No, I mean, are they doing those things where they give you a credit card or direct deposit?
Yes, yes, sir.
All right, what I'm gonna do is I'm gonna send it to you today. And I'm gonna order that $500 be paid towards restitution tomorrow. If it is not paid, a motion to revoke will be filed. Do you understand?
Yes, sir.
All right, state you may be excused. Are you Xavier Crawford?
Yes, sir.
Can you raise your right hand for me?
Yes, sir.
Yes. All right, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, so what do you do for a living?
I work at BJ's.
And do you have any children?
No, yeah.
Do you have family support?
Yes, sir.
And who is your family support?
Mom.
All right, do you live with them?
Yes, sir.
All right. All right, this is what the court is going to do. All right, yeah.
Yes, sir.
This isn't a motion to revoke. Okay. Oh, that's okay. I'm gonna white it out. All right, and have you had any type of mental health issues in the past? All right, the court is gonna sentence you to 5 years deferred adjudication. Just one moment. Oh, no problem. All right, the court is going to sentence you to 5 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 40 days, no employment as a home health care provider or with minors. There's to be restitution to Target in the amount of $3,746.99. And I don't know how he's going to pay the 99 cents because they're doing away with the penny. So $500 to Target, that needs to be in a money order or cashier's check, is due on December 16th, 2025. There's to be 200 hours community service restitution. Why is there a request for healthy relationships?
This was not meant that we were up for that. Big buck probation, this.
All right.
My understanding is it'll be taken into consideration.
All right, so there's to be 200 hours community service restitution. 100 hours will be deemed satisfied upon completion of the Healthy Relationships course, which I'm ordering. The remaining 100 hours will be deemed satisfied upon the completion of the anti-theft course, which I am ordering. And have you had any type of mental health issues in the past? All right, there's to be no contact with Target. That's any Target. So don't go to any Target. Or Michaela Pean, Pean. There should be field visits 1 time per month for 6 months. With regards to a case to be taken in consideration, it's not in your plea bargain agreement.
It's my understanding was to be.
I mean, it's not listed. State, is there something that's being taken in consideration?
I
Okay.
can provide you with the case number.
Well, no. I'm just saying what your plea bargain agreement is with this court. There's no TIC. If the state is saying there's a TIC, then the court will, of course, follow that, but that's not in the plea bargain agreement. Probation, is there anything else that's needed? Is there anything else you need from the court in order to be successful?
He has a setting on the outstanding misdemeanor today.
All right. And could somebody look and find out, is he taken into custody because the bondsman did an affidavit to surrender surety for this case?
He was supposed to come to sentencing in October 23rd. And then the affidavit should be filed.
Okay.
He failed to appear.
And I issued a judge's warrant and remanded with you without bond on October 23rd. Why did you not appear?
Because I had an accident.
Because what?
Because I had an accident in the morning.
An accident what?
An accident in the morning.
What type of accident was that?
I was taking my brother to school in the morning for my appointment, and I got rear-ended
And did you inform your attorney of that?
like hours later.
The court didn't receive notice of that, because if the court would have received notice of that, the court would have recalled the warrant.
Yes, sir.
So what information did you tender?
I didn't get to.
The judge, he called me, I appeared, I notified you. You asked me where he was and some other questions. And I tried to obtain information from the clinic, and the clinic sent me the document that I could not open. So. And then Norma indicated that she would just reset the case.
Normally what?
The coordinator indicated that she would reset the case to a different date. And
I usually have request information. In order for the
Right.
case to be.
right, and we did furnish a request from the clinic to excuse him from court. And I believe you indicated to the coordinator if that wasn't sufficient. So I tried to get something
No, I
more.
mean, in this court, if somebody says they've been in an accident, they need to provide documentation. So my question is, was documentation ever provided to the court?
Beyond what I just described, the request from the clinic, no.
All right, so, yes.
I just want to let the court know that he does have a misdemeanor harassment case, and as part of the agreement that Megan made with defense counsel, it's to be judgment satisfied, not TIC.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand, counsel?
Oops, sorry.
All right, so the court will recall the warrant since this case is closed. And I'm only recalling the warrant for cause number 2025 CR 003791. So if he has a warrant elsewhere, he needs to take care of that. All right, good luck to you.
Thank you, Judge.
And you need to have that paid, otherwise a motion to revoke is gonna be filed.
Yes, ma'am. And where do I bring it? Where do I bring it?
You speak to probation and I'll let you know. Thank you. You're welcome. Who's next?
Page 6, first one, Arnold Benyon. Okay.
Arnold Pena? Didn't think you would make it back.
I might not. So Judge, I've talked to the state, doing some things. Right now, there are about 8 or 9 items that I still need in discovery for talking to test my plan that we either entertain or make a counter offer on plea bargain. So that's kind of where we're at.
All right, Ms. Ferguson, recall this for that first week in January, put it on a Tuesday. We'll come back on January 6th. That's the plea bargain agreement or jury trial.
All right.
All right, thank you. And they'll have you brought over dressed for trial on that day. Thank you. Who's next?
Second, Judge. On page 8, fifth one down, Fulton.
Houghton Kasmerak?
Judge,
Yes.
good
What
morning.
is your client?
Judge, my client's in the Nueces County Jail,
Okay.
and it shows that on the docket, and he's confirmed that he's not here. And I've conferred with Melissa, he just recently got sentenced to prison. I'm gonna try to get a copy of the judgment this week and share it with the state and see if they can make a decision about whether they wanna bring him back or.
All right, do you know what he was sentenced to?
I don't,
The
off
amount?
the top of my head, Judge.
Does anybody want to call the prosecutor in Oasis County and say, hey, what was he sentenced to? All right, y'all want to pick up the phone because there may not be a need for you to come back.
Well, okay.
All right, they'll pick up the phone and call Nueces County and find out what the sentence was.
All right, Judge.
All right, thank you. Who's next?
Page 4, fourth one down, Brianna Luna.
Brianna Luna?
May we approach, Judge?
Yes.
Thank you.
Yes.
Good morning, Judge. Would you like me to first?
Yes.
Thank you. Right. Judge, we have accepted the state's offer for mental health pretrial diversion, and we're requesting the court to allow us to transfer the case, to apply for that and transfer into that court.
All right.
Pending acceptance.
All right, Ms. Ferguson, recall this for 30 days and do a referral to mental health court.
I can do the 15th.
All right, we'll be back on January 15th.
Thank you, Judge. And we filled out the attorney portion of that referral, and I'll turn that in today.
All right, thank you.
Once we get the reset form, may we be excused?
Yes, and why were you late for court?
Struggling with my mental health, I apologize. I will be late.
Okay, no, I just always like to know if there is an issue, just let the court know and you can speak to your attorney and see if there is something that can be solved with about that, okay?
Okay, yes, Your Honor.
All right, so what I can tell you is about mental health court. You need to make sure that if you're planning on entering that program, that you're medication compliant, okay?
I am on medication.
Okay, awesome. All right, thank you. Thank you for dressing appropriately. Thank you. All right,
Thank you,
who's
Judge.
next? You're welcome. Who's next?
While you're looking at that, may I, while you're asked me any of these to look at also?
Thank you. Yeah, but it doesn't. Oh, yeah, no, it needed to be issued. All right, Audrey Bash. All right, the court is calling 2025 CR 008-991 State versus Audrey Bash. Can I have parties announced for the record?
Joseph Stateson for defense.
And are you Miss Bash?
I am.
All right, you entered into a plea bargain agreement with the state. You've applied for deferred adjudication and also for community supervision. According to your plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. This is the run concurrent with 2024 CR 2272. State will take in consideration 2025 CR 008992. Have both parties had a chance to review the TAP evaluation and PSI?
Yes, sir.
Yes, Your Honor.
Any objections from either party?
No, stay here.
Just a few corrections, Your Honor. I've reviewed it with my clients. And you have a copy of it?
Yes.
On page 1, although this goes more towards argument, guilt minimalized, on the PSI specifically is for the firearm. I believe what they're referring to is for the case that's being TIC'd, but she admitted there was a firearm. And for argument, I will explain further for that, but she didn't minimalize the handgun. She acknowledged there was a handgun. On page 2, everything's correct on page 2, but on page 3, under other cases outside Bear County, Kendall County, Texas, she said that there was no state jail prison trip on Kendall County.
Okay.
It was only one state jail trip on page 2, one TDC trip on page 2, and she didn't have a third trip to prison. Same page 3, Tarrant County, just so the court's aware, April 9, 2025, under Tarrant County, Texas. She was in custody here. The typo, it should have been 2015. If you look at the convicted 180-day jail, 11/23/2015. I just don't want the court to be thinking that she had a out-of-county case April of this year when she didn't.
Okay.
Also, page 5, where it says unemployed, she did report that she's self-employed. She has her own landscaping company. She's able to provide for herself if she was to be granted probation. On page 6, it says that she although to the left it says none for DWI education, to the right it says yes, which could be for AANA. She has done AA. She just wants the court to be aware that she's never had a DWI. She's never had to take DWI education class. And page 9, although this is not really a correction, it's just so I can point out, they wanted proof of full-time employment under other within 30 days and provide proof of education within 30 days. She's saying that she received 2 GEDs, one in Arizona, one in Texas. In 2001 and 2017, she did have a GED. The 2017 was in Bexar County Jail. Aside from that, there's no other corrections, Your Honor.
All right, state, you're opposed to the application?
Yes, Judge, yeah, again, I don't have any evidence.
Okay. All right, anything your client wishes to say?
Yes, Your Honor. I would like to call her, but if I can do some argument first. We were here previously, although, okay,
I think it's best that I take testimony and then I'll allow both parties to do argument.
can I call Audrey Bash?
Yes, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand.
Ms. Bash, you're currently on probation supervised from this court. Yes?
Yes.
All right, you need to speak up so the court reporter can hear.
And you're asking this judge to grant you reinstatement and probation on this new offense?
Absolutely, yes, yes, yes.
You're willing?
Okay, so here's the thing. I can barely hear you. You're a distance away from the court reporter. I know the court reporter is struggling. You need to speak up.
Yes, ma'am.
Yes.
You're willing to do anything this judge imposes of you for probation?
Absolutely.
And
Then, I'm sorry. Then why haven't you been doing it? Like people always say, I'll do whatever you want me to do on probation. You're already on probation. In your statement on page 7, it states, when asked why she felt she should be granted probation, the defendant stated, it's hard to be in jail. I don't want to be here or in prison. If you don't want to be in jail, and if you don't want to be in prison, then why do you keep doing this?
I was doing my classes. I was told to do the IOP classes here. I did 18 out of the 20. The day I came to jail would have been my 19th.
But we're here for a new case. That means that you picked up a new offense.
Yes, ma'am.
So why? Why do you keep doing this? It seems like you want to go to prison.
I do not, ma'am.
Then
I know to be better, I have to do better. And since I've been in here, I've done every class that they could give me. I'm trying to do better. I
here's
do
the thing,
understand
people
that.
always do better when they're in jail. Normally, I will have people, they come before me, and when they're in the free world, they don't do what needs to be done. When they're in the jail, it finally hits me, oh, I'm in jail. And then they start taking every class they have at the jail, as evidenced by the fact that your counselor is saying, I've done my GED twice, when you only need to do it once. But people always become focused when they're in jail because they don't want to go to prison or they don't want to be in jail. So my question for you, why would this be any different than before?
Your Honor, I'm old, and I know that I just don't want to do this anymore. What happened was I let fear control me and make a bad decision, and that was wrong. I was being threatened.
So how old are you?
42.
So you've had this MTR since last year.
No, ma'am.
Well, you were placed on probation on
In
2024.
September, and
So I mean, you were maybe a year younger than you are today.
and I was really trying to do everything that I could, and I do believe that I can do better. If given the chance, I know that I can do better. I can be better. I can do better. I do
Your Honor,
believe that.
the threatening that she had, she is a victim of robbery. I tried to find it. I went back in time on YouTube to try to find it. There's a case here, family violence. Rick is familiar with. I've asked Rick to pull up the case information. He couldn't find it. I was in court here and there was a Spanish sentencing. And there was a person who was very loud talking in Spanish. I don't speak Spanish. But when the state had said that there's multiple victims, that lady was sentenced to prison. They said that the restitution was going to Audrey Bash, but they didn't know her location at the time. I've asked them to to try to find that. I couldn't find that case. I don't have a way to search that. But she understands that a gun is not supposed to have a gun on felon probation. If she were to have a gun after the 5-year period elapsed after she was discharged, cases ended at her house for protection. But she had some bad relationships. She had struggled. She had a relapse. She wants to be a licensed clinician, dependent counseling to help other addicts recover. She believes she can stay sober. She won't be around firearms. I've never had somebody take upwards of 20 classes at the jail. People usually take 2 to 3. And she, not only took, I think it was 19 classes, but the AA meetings and 10A meetings she's done, it's multiple. It's not just 1 or 2. She's actually participating. She's not crossing her arms, defiant. She's willing to do probation. It's her first MTR. I know that there's 2 new offenses, hoping that you would give her a chance.
All right, state.
I guess I did have some questions for the defendant.
Oh, you may proceed.
Ms. Bash, so you were placed on felony probation in September of 2024, correct?
Yeah.
Okay. And so as part of your conditions of probation, you were supposed to report to your probation officer. Do you recall that?
Yes.
Okay. And so it would appear that the last time that you reported to your probation officer was in February of 2025. Is that correct?
No, I didn't. March also, I was in my class and my teacher, we reported by phone.
So I'm talking about going to the probation officer and meeting with your assigned person at the field office. Okay, so the last time you did that was in February 2025, correct?
Yes, ma'am.
Okay. And the address that you provided to probation at the time that you were placed on there was 1126 King Avenue, apartment 6. Were you living at that address up until your arrest?
No, oh, yes, no, ma'am, I had moved, but I told them on my address.
Okay, and what was you told them your new address?
Yes.
Okay. Now, as part of, because you are on felony probation for drug possession, you acknowledge that, right?
Yes.
Okay, and so part of the conditions that the court placed on you to help address this issue is for you to go to partake in urinalysis. You recall that, right? Okay, and so you had been ordered many times. So starting in January 2025, you did report to provide a urinalysis. Is that correct?
Yes.
And that was positive for amphetamines and marijuana, correct?
I believe so.
Okay, and then in February of 2025, you did not appear to provide a urinalysis, correct?
I don't remember being told to do it that day.
You don't remember being told to do
No.
it that day? Well, I guess it's fair to say the last time that you did it was in January of 2025, right?
Okay.
So the last time that you provided your analysis was in January 2025?
Yes, ma'am.
Okay. And so then in your PSI, you deny that you were under the influence of any alcohol or drugs at the time of your new arrest. Do you recall that?
Yes, ma'am.
But when we look at the stipulated evidence, the officer states that when he approached you, you appeared to be sleeping in your vehicle. Do you acknowledge that?
Yes, ma'am.
Okay.
It was raining and the roads were wet and I pulled over rather than getting in an accident, I fell asleep driving one time before and I killed myself. And I would rather not do that again. I wasn't on drugs because if I had been, I would have been awake.
Okay. And so
I
what
didn't
is
know
this
they
that the
were-
officer is saying that he could smell marijuana in your motor vehicle?
I was asleep. I wasn't smoking, I was asleep.
So when was the last time that you smoked marijuana in that vehicle?
I don't remember.
You don't remember?
No, ma'am.
Okay.
And I don't think it was me. I think it was the person that I let my car to. Earlier that day.
Okay. So then further in your PSI, you state that the last time that you had used methamphetamines was 10 months prior to your arrest. Is that what you said?
I believe so.
Okay, but
I
you were
did.
found in possession of methamphetamine
I
on the
did,
date
yeah.
of the offense, correct?
I did not know that it was there. If it had been mine, it would have been on my person. I would have known that. I didn't know that it was in the floorboard of my car because I gave somebody a ride to work. It would have been, in my possession. I really did not do that.
Okay, well, notwithstanding you disputing those facts, okay? You were arrested in May of 2025 and had a positive UA while on felony probation for methamphetamines in January 2025. So please tell me how many months that is. It's 5, right? Not 10. So you're not being truthful to your PSI officer or this court about what you're doing on felony probation, correct?
Yes, ma'am.
Okay. And then further in your PSI, you're stating that you should be granted probation because you don't want to go to jail, not because you want to change or not because you want help, correct?
I want help, ma'am. I would like help. I'm trying to be a better person. I'm doing everything that I can to be a better person.
Okay. So if you wanted help, why did you not reach out to your probation officer? Or why did you not show up to your UAs? Or why did you not show up here to the court to ask for that?
I was doing the classes and I was doing the classes that they gave me, the IOP classes here at the probation office. I had reached out to my teacher and told her that I was having a hard time. But I was doing that. I mean, I thought that there would be a record of that.
Did you notify anybody that you were actively engaging in using controlled substances besides your IOP teacher?
No, ma'am.
Okay, because you understand that the IOP teacher is not the correct person to report that to. It's your probation officer, right?
Okay.
You understand that?
I'm doing that. Yes, ma'am.
And so I guess ultimately what you're telling this court is that you just don't want to go to jail or prison because it's hard, right?
No, ma'am.
That's what you
That-
stated in your PSI, right?
And it's not that's not it at all. I would really like to be given a shot to be a better person, to do better, to prove to myself in the court that I can do better. Prison is easy. I mean, you do what they tell you to do and that's it. But when I've done probation, I've free and cleared probation with no violations. I've free and cleared parole with no violations. I believe that I can do better. I truly do. I want to be better. I know to be better, I have to do better. And I'm prepared to do that. I know that probation is very rigorous and I'm prepared for those things. Anything that you give me, and I'll be happy to do. I want to be better and do better and help others be better and do better.
Okay.
I believe that.
Well, would you agree with me that given your history, the state and this court has already given you a chance by placing you on felony probation? And here we are because you cannot violate or you cannot abide by the terms of felony probation. You'd agree with me, right?
I believe that I made a mistake once and I would really just beg mercy to please get a second chance.
When you say that you've made a mistake once, I mean, this is not the first time that you've been charged with a criminal offense, correct?
No.
Yeah. So that's more than once, right?
I'm asking for a shot. A second shot for this, but I don't know what to say there to her anywhere she's.
May I briefly
Pass the
respond?
witness.
All right, so I'm going to give you a choice today. These are your choices. There are no other choices. One, I can place, you say you want the help, I'll give you deferred adjudication. The state is offering you a cap of 6. If I give you deferred adjudication, the full range of punishment is open to the court, which means up to 10 years in the prison. You are not going to ISF. I don't think ISF is appropriate. You'll be at the jail waiting transfer to SafeP. And the SafeP program is a 9-month program. And then you have aftercare for 3 months. Or if you would like, I'll sentence you to prison. I'll sentence you to prison for 5 years. Those are your only 2 choices. Which do you choose? And see, this tells me right now, she really doesn't want the help, that she's trying to figure out back time. But you can discuss it with her. No, those are my only 2 choices. Those are your only 2 choices. There are no other choices. You can either do 5 years in the prison or either you are going to do 10 years deferred adjudication. Those are your two choices. No other choices for you. So which do you prefer?
I'm sorry. Um,
One moment.
All right.
Oh.
And if she chooses prison, it doesn't hurt my feelings.
Your Honor,
Yes.
we're ready to proceed forward. She has her answer.
Right. So which does she prefer?
5 years TDC, and we would ask that that would run concurrent with her MTR. We would ask if you would reform the judgment of the 10-5.
Oh, just 1 second. We haven't done that case yet. All right. So in cause number 2025 CR 008991, the court will sentence you to 5 years in the prison. I'm sorry, the court is going to find you guilty, sentence you to 5 years in the prison. Give you credit for any time served. This will run concurrent with 2024 CR 227. I'm sorry, is this 2272 or what? 2272. Take in consideration 2025 CR 008992. And I'll request the therapeutic community. Is there anything else in that case with regards to sentencing?
Yes.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? With your attorney, did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. Do you understand?
I do.
All right, we're going to proceed in 2024 CR 2272, and that cause number you previously pled true to violation of condition number 1. The court found violation of condition number 1 true. And your range of punishment on that case, the court could sentence you anywhere up to 10 years in the prison. And state, what are you requesting?
Judge, we are asking for revocation and 5 years to run concurrent with the prior cause.
That's our recommendation. We ask that you follow it. I've previously conferred with Megan. If there was revocation, we would ask you to reform the judgment to match the sentence.
All right. Are you waiving your right to appeal?
I am.
Okay.
Thank you, Judge.
All right. And that cause number, the court is going to sentence you to 5 years. Give you credit for any time served. This will run concurrent with 2025 CR 008991. And the court will request the therapeutic community. State you may be excused. Thank you. Did you review the document certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
I did.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak with an attorney. Do you understand?
I do.
All right, good luck to you.
Thank you.
You're welcome. Oh, and counsel, let me give this to you and your client before you leave. And then you have someone who's on Zoom. Yeah.
And I'm ready for that.
All right. Thank you.
Yes.
So night dismissals for.
There you go.
Thank you, Your Honor.
All right, and what page is he on? Airstead Brown.
Ready.
All right. All right, State, were you able to tender an offer? And were you able to tender to your client?
I did, Your Honor. However, I'm preparing the mitigation packet to Ms. Galloway. He's already completed 2 courses. I've asked him to take a total of 5. I previously sent him 4. I asked him to take 1 more. I had also asked Megan for discovery. I did receive the discovery. I don't believe I'm missing any videos at this time. Last time they were dash cam videos I was seeking, but I have them.
All right, Ms. Ferguson, set this for a plea deadline week, the 3rd week in January. After that, it's going to be a quick turnaround for jury trial. And your client can appear by Zoom for the plea deadline date.
Yes, Judge.
All right, January 22nd. All right, thank you. All right, Mr. Brown, you're excused. We'll see you back on January 22nd.
Okay, appreciate it.
State, were you able to get in touch with Nueces County?
No, Judge, I called and they sent me to voicemail. I did find out that it is a burglary of a habitation, so I asked my investigator to run a new NCIC to hopefully it shows that.
Mhm.
So if I could just have a few more moments to see if I can get that in.
All right, any objection to the court calling?
No, Judge.
All right, and who's your client again, Mr. Hancock? What page is he on? What's your client's name, counsel?
Colton Casmeric, Your Honor.
All right, and you say he's in Nueces County?
Yes, ma'am.
All right. Any objection to the court calling?
Oh, no objection. Judge.
All right, let me do this real quick.
Do it on YouTube, please. So-
All righty. Will do.
Okay.
Yes, this is Judge Boyd in Bear County, Texas. Oh, yes. So they tell me 4 years. Yeah. Thank you, Renee. Yeah. All right, who's next? Andre Warrants.
Present on him, Your Honor.
Thank you so much. But yeah, I just ended up calling a prosecutor over there.
Oh, cool.
Yeah, I just Googled and I just went to a different court, but she was great help. Good morning. All right, so what is happening with regards to surveillance videos?
So yes, in reference to that, my client did notify me that he's been trying to send me them. He believed that they have gone through, but it seems the file is not supported. That he's trying to send to my email. So what I can go ahead and do, Judge, is do an investigative request from my investigator to get these videos from him so that I can review before hopeful next court setting. And then I know that the state also did look into a body cam for the person on scene. And it seems like it was a Medina County Reserve officer that was working security there. So she went ahead, Lauren, and reached out to see if he had any body worn cameras.
Okay. All right, Ms. Ferguson, this will be the final date for discovery. If you can give me 30 days, is that enough time for both parties?
Yes, Your Honor.
For a final discovery date? All right, January 15th. Once you sign the reset form, you're excused.
Thank you.
All right, thank you. All right, who else is ready? Cassandra Garza.
Here, Your Honor.
All right, so good morning. So how's PTD going?
It's good, Your Honor. We've been accepted. I have the stamped copy that's been received by the DA's office.
Okay, awesome.
We're in the program, we've accepted the contract, we've signed it and turned it in.
All right, just make sure you follow through on everything, all right?
Yes.
Ms. Ferguson, I need a PTD date, please. All right, January 15th. Once you sign the reset form, you are excused. And counsel, if she has completed everything and I receive the dismissal, then I will have signed it before that date. But if not, she'll need to appear.
Yes, Your Honor.
All right, thank you. Just have a seat. Your attorney will bring your reset form. All right, who's next? David Cortez Jimenez. Hello. Good morning. Let me see something here. All right, today is the plea deadline date.
Judge, my client requested in court for more time. He hasn't talked to immigration. He's not a US citizen. He's worried about being deported.
Now, this is being set for a jury trial. Norma, set this for a jury trial. I'm sorry, are you a Spanish speaker?
Yes.
Are you able to understand everything that I'm saying?
I understand a little bit, but
Well, Norma, have an interpreter come down, just have a seat. Time when the interpreter's here, we'll bring you up. And Norma, I'm gonna need a jury trial date for the first week in January.
Thank you.
All right? Okay. Yes, for him. Because this case has been going on since August. All right, do you have someone else? Sorry, who on?
Page 13, fourth one down, Henry Sullivan.
All right, thank you.
Judge, thank you for.
Not letting people put off for tomorrow what can be done today.
No, I learned.
I'm sorry, if you could cite just a second. All right, Norma. Mr. Kasmeric case has been resolved and there's no need to have him transferred from Nueces County. You're welcome. All right, and Henry Salazar. All right, why were you late for court?
having trouble with parking and then long line outside.
All right, so here's the thing, you need to adjust for those in timing, all right? But thank you for dressing appropriately for court. All right, State, were you able to amend the MTR?
I think we are working on the amendment for the MTR judge. Additionally, defense counsel brought it to our attention that Mr. Salazar has retained counsel. So we can.
All right, who's the retained counsel?
Your Honor, that's going to be Mr. Mark Hole. And then I think that there's a Hillary.
All right, so.
Hillary Crossup is supposed to be appearing for them today.
All right, so just have a seat. You need to call and tell your other attorneys to appear. All right, thank you. Thank you.
Can I make two, Your Honor?
Yes.
Thank you.
All right, who is here on? I'm sorry, who's next? They're not great on this, his attorney needs to appear. Do you have anyone else? Yes, on page 10, fifth one down. Adalia Sobs. Hello. Hi, where's your client? They're in custody.
Oh,
Yeah, just have them request to bring him up.
didn't say that. She's in custody.
All right,
On bond.
thank you. Anyone else?
One down. Yeah.
Shakira Laraga, sorry. Hello.
You're right, you're right.
All right, so in this case, has the evaluation been completed
It has been, Your Honor.
and the results?
She was found confident and sane at the time of the offense.
Okay. And you had the hearing in magistrate's
Magistrate
court?
court, yes.
All right, thank you. All right, so then today is plea deadline date.
Yes, we have received a new offer. There's some missing discovery that Ms. Galloway is going to look into. And I do need some more time. The discovery is somewhat voluminous, so I need to go over that with.
All right, and what discovery is missing?
There's a body cam where the officer's approaching the vehicle. It's the first officer to approach. So we have other body cams, but not that body cam.
Okay,
That's kind of an important body cam.
and is that the only missing discovery?
And to our knowledge, yes, but it is somewhat voluminous.
All right, Norma, can you recall this for final plea deadline date on that first week in January, Thursday? All right, so we will be back on the 8th. Once you sign the reset form, you're excused.
Thank you.
You're welcome. Thank you for dressing appropriately for court. All right. All right, if you'll bring the interpreter up, please, and bring your client. All right, Mr. Cortez. All right, your case has been in this court. It's an old case. I believe it must have been transferred here because it has a 2019 indictment date. But your case has been in this court since August of 2025. Your jury trial date is going to be January 6, 2026. You will be going to trial on that date. Do you understand?
Yes, Your Honor.
All right. and defense, before you leave, I need you to sign a discovery acknowledgement state on Cortez 2019 CR 6016. He's on page 11.
Yes, ma'am.
And it's David Cortez Jimenez. I need an acknowledgement of discovery filed in some.
Okay.
All right, and Ms. Ferguson, if you'll give him his reset form. Do you have any questions?
No, sir.
No, Your Honor.
All right, thank you.
Thank you.
Thank you.
Who else? Page 4, third one down. Okay, we got it.
Rogelio Ibarra?
Your Honor, may I just approach before?
Yes,
For your signature.
of course.
Thank you so much.
Thank you. And that's for this case, correct?
Yes.
All right.
I'll fill it out.
Oh, okay. All right, thank you. I was gonna
Thank you.
find the cause.
It's okay, no worries. Thank you. Have a good day.
All right, you too. Hello,
Hey, Judge, good morning.
good morning. Let me see here. All right, so where are we? I think you wanted some drug testing.
Well, there's some,
Data?
there was lab stuff that we had been requesting.
Mhm.
We technically have not received that. However, I've been in communication with Mrs. Galloway. And I think we're close to working this case out. She does need to verify some information that I provided to her. And I think after that, I think we may have an agreement.
Okay, and how old are you, sir?
I'm 18 now.
All right, Ms. Ferguson. I need a date for disposition the third week in January. All right, we'll be back on January 22nd on that date. This case is either going to be resolved by agreement or either it's going to be jury trial.
Just, just.
All right, thank you. And once you sign the reset form, you're excused. Jury trial and disposition. I should say jury trial. Yeah, jury trial or disposition.
Oh, you can do it.
I took the discovery acknowledgement, but I don't know where Mr. Rutledge went.
I think he's about to sign it. Reset form. Get back to me. I think he stepped out.
All right, Norma, can you call him and have him sign this document, please? Thank you. Is Mr. Hagee here? Austin Hagee? Okay, I think he's outside. Thank you.
Yes, ma'am. I didn't see him.
All right, Norma, have him come back. Rutledge.
Here.
All right, who's next?
Page 7.
Lincoln Martins. Lincoln Martins. Okay, just have a seat. Who's next? Who's here on Manuel Moses Ramirez? All right, we're waiting for his attorney. Who's next? Carlos, who are you here for?
You brought back last week,
Juliana Guzman. And I totally agree with, I mean, it said earlier, that we can work it out today while we're.
Yes.
We're working on it.
Okay.
They gotta do my paperwork. Okay. It should be a plea judge.
All right, thank you. All right, who's next? All right, Belena Page. Who's the attorney? All right, come forward, please.
Yes, ma'am.
Okay. It's gonna be one of those days. I didn't start off on the home row keys, I should say. All right, so today is supposed to be plea deadline date? And,
We have an agreement, Judge, we need to set it.
all right, Ms. Ferguson, I need a jury trial date. How long do y'all expect this will last? All right, 3 days. So your plea deadline date has expired. The court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. Do you understand? All right. All right, can you do it earlier in March, or that's the only thing that's available? All right, we'll bring you back on March 10th. That will be your jury trial date. And I need an acknowledgement of discovery.
Yes, sure. I'll get that right now.
Mhm.
That's spring break, not available that week.
All right, the week after March 10th. Or either the end of February.
We can do February as well, and then February. we have 24. Okay. Thank you.
What, February 24th?
Yes.
Hey, Black History Month, I'll be here. All right, February 24th will be your jury trial date. Who's next? All right. Are the parties here? Manuel Moses Ramirez. Who's his attorney? Hi, you have Mertens.
Thank you, Judge.
Let me find what page he is on. Hello. All right. So do you have the discovery now?
I do need to go through it, Judge. It's about a terabyte worth of evidence, and I need to go through to make sure that is all the evidence. We did receive our first offer today,
Okay.
and so I've reviewed that with them, and we need to go through the evidence and consider that offer.
All right, Ms. Ferguson, set this for a plea deadline date at the end of January.
Fine.
All right, so January 26th will be your plea deadline date. At that time, you need to let me know whether or not you've reached an agreement with the state. If you have not, your next court date will be a jury trial setting, and the court will not consider any plea bargain agreements without good cause, or you have to plead open to the court after that time. Do you understand? All right, how old are you? All right. Do you have any questions about anything?
Are you like fire reduction?
Oh, your attorney will have to file something, and then the court will consider it. And counsel, he says he's 18. Do you need longer than that date to go over things with him? I just find that young people, sometimes they don't understand the consequences
We have gone through the initial.
or internalize everything, I should say. All right, then that will be your That will be your plea deadline date.
Okay, good.
I want to put that.
Oh, thank you. You too. And counsel, if you want to file motions and have them heard, you can. And counsel, on that case, if you could do the acknowledgement of discovery, please. State there needs to be an acknowledgement of discovery on Mertens. All right, just give me a moment. All right. Is Megan here?
Here's draft file, Your Honor.
Okay, all right, thank you. All right, the parties on Manuel Moses Ramirez.
Your Honor, on the acknowledgement from Mark, it will keep that looks like 4 or 5 pages. Is it all right if we just do all clause numbers on one cover sheet?
Sure,
As long as you're okay with that.
yes.
Thank
And
you.
the clerks are? Clerks, are you okay with that?
If I do one cover sheet for all 5 clause numbers for what? On Lincoln Martin's discovery acknowledgement.
And what page is Manuel Ramirez on? Thank you. And are there applications?
No, Your Honor.
All right, probation, there are no applications. Court is calling 2025 CR 013930, State versus Manuel Moses Ramirez. Could I have parties announced for the record?
Lauren Espinoza for the state.
Sean Sheffield for defendant. We're ready, Your Honor.
All right. And are you Mr. Ramirez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. All right, I'm trying to find your true bill of indictment. All right. Yeah, it's not here. All right, thank you. Oh, no, found it. It was stuck to another document. All right, Mr. Ramirez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did, ma'am.
Your client needs to sign that.
Oh, I'm sorry.
No problem. All right, your charge of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes,
And did you intend to give up those rights and enter into a plea in this case?
ma'am.
Counsel, has your client been able to provide you with any defenses?
He has yours.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Ramirez, has anyone threatened you,
No.
coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Indeed, ma'am.
According to the plea, punishment is to be assessed at 12 months in the state jail facility. There's $1,000 fine and no applications. Did you understand that to be the plea?
Ma'am.
Defense, is that the plea?
It is, Your
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? Guilty,
Indeed.
not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. State offer states exhibit 1 and all attached with.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Sure did, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We'd ask you, so, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we just asked the court to follow the recommendation.
All right, the court will sentence you to 12 months in the state jail facility, give you credit for any time served. There's $1,000 fine, time and money to run concurrently, and I'll suggest the therapeutic community for you.
Thank you, Judge.
The therapeutic community doesn't increase the time that you're in custody. It's just to help you with your sobriety. I do not have the authority to force them to place you in the program or order them to place you in the program. They'll just see on the judgment that I'm recommending that for you. When you get to the state jail facility, you'll have to request it as well. Do you understand?
Yes, ma'am.
All right.
Thank you.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess. You're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, I do.
All right, we can go off the record. Here's the thing. How old are you?
I'm 41.
All right, you're 41. If you continue on the path that you're on, only 1 or 2 things are going to happen. Either you're going to end up being in prison or the Bexar County Jail or somebody's jail for the rest of your life, or either you're going to end up using, and the last time you use may be the last time you use, because you never know if you're going to overdose, if somebody didn't make it correctly or what. You understand? Because the people who are selling that, they're usually not concerned about the person, because otherwise maybe they wouldn't be doing it. It's usually selfish reasons, all right? When you're released from custody, if you can't find a place that can help you with your sobriety, you come back here, I'll pick up the phone and I'll see if I can find transitional housing for you.
I appreciate it.
And in that police report, I saw that you were with someone. You can't help somebody until you help yourself.
Right.
So if they're using, it's not good for you to be around them because they're gonna feed into your use, all right? All right, good luck to you. Thank you,
Thank you.
council. All right, could I see the parties on Malik Lampkin, please? Okay. Yes. Well, let me get this date from Norma on this one, then I'll be ready on the next one. All right, Norma, what date? All right, we'll see you all back then. You're welcome. Oh, and counsel, Megan.
The reason for that, Tim, we have a witness we're trying to locate as well.
All right, and State, do you have any objections to the oral motion for continuance? They say they have more witnesses. All right. So we will recall Mr. Lampkin then back on January 26th. Hello. Oh my gosh. Becky, you're so awesome. I'm on my security. Yes, please. But this brings back some memories. Even though LSU did do great this year, she's still honored this. Thank you so much. You're so awesome. Hey, but you know what? Here's another. This is something that we share. We share. Thank you so much. Hey, Merry the first back. Hey, Merry Christmas. Have a great one. You'll be safe. Is it mom? Oh, hey, you go. Well, that'll be fun. Well, congratulations. It's gonna be fun. And the new year is gonna be better. Okay, I will. Thank you. Right. So Becky is on the CPS side and she's asking me, she said, we'll be fine as long as I pull for Texas Tech. She's so awesome. All right, everyone, just give me 2 minutes to put this in the system. Probation. Lampkin is being recalled for January 26th. Defense counsel has more witnesses. And they're going to speak to you all about a possible facility. All right, who do we have next?
Fifth one down.
Israel Gonzalez.
One, Your Honor.
Good morning. Oh, Israel Gonzalez. All right, and this is family violence and criminal trial division.
Yes.
So the state was to make a global offer. Has that been done?
No, Your Honor. We're here for the discovery today.
All
On
right,
the robbery, because the other one, the one that deals with family violence has not been indicted.
all right, family violence, if you'll come forward.
And I've spoken to the state, but they seem want on the criminal side defense of it.
All right. So this is
This is a robbery.
Gonzalez, Israel Gonzalez. It's 2025 PF 20635. And so today it was supposed to be a global offer that is made. And are you on the PF case?
Yes, sir.
All right, so where are we on discovery on the PF case?
I've been getting discovery, but I get this new discovery if once it reaches the point where they're gonna be indicted, it keeps them in discovery, but I've gotten some discovery on it, and the discovery that I did really recently viewed entirely was on the robbery, which is the same situation or the same complainant. Okay, now that's the one I received a whole slew of evidence and on that, on videos and discovery. There is one thing that I believe it's not in there that I didn't see was any phone records connecting my client with the complainant.
All right. So,
And just to have you know, Your Honor, this should probably be a trial.
okay. So what is outstanding? Is there anything outstanding on the assault peace officer or the robbery case?
I told Miss Carrillo that I need more time to look because there were people ahead of her,
Yeah.
my staff,
Yeah.
and I've not had an opportunity to look and see if what she's asking for has to come to her.
All right, so let's step back and the state will review and then I'll call you back.
Okay, Your Honor, I gotta be in two of, can we come back tomorrow? Because I have a motion to amend his GPS. Okay,
No, because we're in trial, so I'll just confer with the state and then I'll take
All
this
right,
matter. All
okay.
right, thank you.
you take that up when you take up the motion?
You'll need to speak with the state and see if they're ready to proceed on your motion.
Okay.
Thank you. Who's here on Angel, Joe, Ojoel, Varela? And are you all ready to proceed on the motion?
Yes, Your Honor.
All right. Probation, this is a motion to revoke.
Good morning, Your Honor.
Good morning. All right, the court is calling 2019 CR 7765 State versus Angel Joel Varela. Could I have parties announced for the record?
Ashley Jones for the state. Here, Corby for Mr. Varela, Your Honor.
And are you Mr. Varela?
Yes, Your Honor.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? And did you understand it?
Yes, Your Honor.
Are you the same Angel Joel Varela who's placed on deferred adjudication in 2019 CR 7765 for the offense of burglary of a habitation with intent to commit assault on June 13, 2022 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. We are going to go forward on violation of condition number 1 from the supplement on first amended motion to revoke. That is on or about the 17th day of March 2024 in Yuma County,
Oh,
Arizona.
I'm so sorry. I don't have the supplemental.
Uh,
All right, did you review the supplemental motion to enter adjudication of guilt and revoke community supervision with your attorney as well?
That's the one I signed, correct?
No. It's telling you.
Oh, yes, Your Honor.
All right, The supplemental motion is telling you what allegations the state is saying that you committed that are a violation of your probation. Do you understand?
Yes, Your Honor.
And did you review the supplemental with your attorney as well?
Yes, Your
All right, they're just gonna get that for me because I don't have it. All right, thank you. Sometimes it gets lost in the system. Thank you. All right, state, you may proceed. Oh, it's still the First Amendment. I thought you said supplemental.
No, I corrected First Amendment. Your Honor.
Ah, then I have that. All right, let's proceed.
All right, on or about the 17th day of March, 2024 in Yuma County, Arizona, the defendant Angel Joel Varela committed the offense of aggravated driving under the influence in violation of condition number 1.
How do you plead to that, true or not true?
Honor.
And the state will waive the remaining violations, Your Honor.
Any objections to the state's waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. The proposed agreement is that the court grant the the state's motion to enter adjudication of guilt, revoke the community supervision, and sentence the defendant to 3 years in the Texas Department of Corrections.
All right. Is that what you're requesting, counsel?
It is, Your Honor.
All right. Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right. And can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand, state your name for the record.
Angel Joel Varela.
All right. What have you completed on probation?
Well, Your Honor, on probation, I was going to work, being a law-abiding citizen, just trying to do my best to stay out of the way. Or be a good father to my kids. And really just my cousin, he passed away. I was really close to him.
Just stop in real quick.
Yes.
While I'm thinking of this, when we signed the paperwork, I told him he did have a limited right to an appeal, and you did ask him if he was waiving his right to appeal. So can I just explain to him what that means?
Sure.
Yes. Okay.
All right. So what have you completed?
Having a job and being there for my kids.
I mean, everybody does that.
And while I was in prison, I completed anger management classes. I completed a cognitive behavior classes.
So you've been sentenced on the other cases?
Judge, he was sentenced to up to 2.5 years in Yuma, Arizona. I believe he did a 1.5 years. If I'm reading the
Do
judgment,
you know that cause number?
yes. You ready?
Yes.
It's number S1400CR 2024000523.
All right. So you completed cognitive and that was while you were in custody?
It was just anger management
Cognitive anger management, there's another one.
and behavior analysis.
And that was while you were in custody?
Yes.
And that happened while he's on probation.
Okay. All right. This is what the court will do. The court is finding violation of condition number 1 true, and that's the violation with regards to aggravated driving. The court will grant the state's motion, revoke, sentence you to 3 years in the prison. This will run concurrently with S1400. Did you say CR?
Yes, Your Honor.
CR 2024000523. There's an affirmative finding of family violence. There's to be no contact with Liliana Martinez. There's to be no unsupervised contact with minors. There is a $1,500 fine. Time and money will run concurrently. And according to your plea bargain agreement, there's no outstanding restitution. Is there anything else with regards to sentencing?
Not from the state.
Judge, it's just, he wants me to make sure he's getting his back time for all the time he did Bear County, which I know I think he's entitled to, right?
Yes.
And then you're giving him his credit for the time that he served on this case in Yuma?
Yes,
Thank
and
you.
it's running concurrently. And legally, I must give you credit for any time served.
Okay.
So that's, sometimes I don't say it because it's automatic and your attorney knows that it's automatic. But sometimes we forget that people who are not in the legal field don't know. So the record is clear. You're entitled to credit for any time served that you're in custody on this case. And you're entitled for any credit for any time that you were in custody out of state, as long as this warrant was pending. So if there was not a warrant pending and you were doing time somewhere else, then you're not entitled to that credit. Once a motion to revoke was filed on this case, then you're entitled to credit from that point. And your attorney will check to make sure that that is accurate. All right, and if for some reason you go to prison and you find that it's not accurate, what will usually happen is we will receive a letter, it will be reviewed. And usually if everything is correct, what you're saying, someone will double check it. And then when they double check it, I'll sign a motion or an order granting you any time that you feel that's appropriate. You understand?
Yes, Your Honor.
And that's proven to be appropriate. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go with the record. Do better. Otherwise, you're going to find yourself living your life in somebody's prison or somebody's jail. You understand?
Yes, Your Honor.
All right, good luck.
Thank you.
You're welcome.
Thank you, Judge.
Thank you. Thank you.
Appreciate it.
Anaya Gifford.
Yes, Judge. It's PSI.
Okay.
Can she come forward, Judge?
Yes. I've been told by Becky on the other side, on the civil side, I knew her from CPS cases. She said, hey, you got to cheer for Texas Tech.
No, you don't. No, there's no requirement.
Now, Kelly is saying yes. You all don't have to
That's one
debate.
reason not to cheer for Texas Tech, Judge.
There's going to have to be a debate, right?
Judge, as long as the Longhorns are out, I'm happy.
Ooh. Ooh.
Shorthorns.
And have you talked to Jason Garhan
No.
about what is he, Texas A&M? Yeah.
It's kind of a cult.
And has somebody talked to Notre Dame? They're still upset.
You have deprogramming for all the A&M fans.
I don't even know if I should take this up because of Oklahoma.
Do it for my dad.
Okay, all right, I'll do it for him. He has LSU roots. And your mom. Their love story was so great. Your sister told me about their love story.
She took them by my dad getting arrested.
Yeah, she told me about that and I can joke with him. We've known each other forever. All right, the court is calling 2023 CR 5888 State versus Anaya Gifford. Can I have parties announced for the record for the state?
Megan Galloway for the state.
For the defense?
For defendant, Your Honor.
And are you Miss Gifford? All right, you entered a plea of guilty on October 16th. There was a request for a PSI. And according to your plea bargain agreement, punishments be assessed at a cap of 8 years in the prison. there's $1,000 fine. The state is opposed to your application. And there's restitution of $12,000 to Mr. Holtzworth. Have both parties had a chance to review the PSI?
Yes, I've reviewed it, Your Honor, and I have no objections.
I don't have any objections, Judge.
All right, and are there any witnesses?
The state has no witnesses, Your Honor.
No, Judge, I just have argument.
All right, the court will hear argument. State you're opposed.
I am, Your Honor. I'm asking for the court to deny the application and sentence her to 8 years and reserve the rest of my time.
All right, just one moment. Let's see. All right, you may proceed.
So, Judge, I want to point out, from looking at this, Ms. Gifford was sentenced to a federal prison for I guess, a conspiracy charge that I think this case arose out of. She was released, I think, actually with a warrant in place from the federal penitentiary, and then made bond here. And I don't know why this was not included originally with the federal prosecution, or if in fact, I don't have a copy of the federal PSI, and I can't really determine whether or not the complainant in this one is actually a complainant involved on the federal case. And if the court notes, there's a restitution amount among all the people who were sentenced of $1,235,000. Ms. Gifford's currently paying restitution to federal supervised release, which is the federal equivalent of parole for this, the federal charges. And she's employed now. She lives in Georgia, and I guess, is capable of, paying restitution on this case. If the court grants her deferred, obviously it would have been better for her if this case had been included in the federal sentence. And I think, how much?
I got sentenced to 57 months and I served 30 months.
So if the court doesn't grant her application, I ask the court to give her credit for the time she spent in the federal penitentiary. Since this is in fact, I think, out of the same fact pattern, and I think the same conspiracy. But I would ask that she's been released and she's paying restitution now, that the court grant her probation and let her pay restitution on this case as well. Like I said, I have no way of determining what restitution was ordered. I would assume it's jointly and severally among the conspirators, but I don't know if the complainant in question on this case was one of the complainants on the federal case.
All right, and my understanding in this case, and correct me if I'm wrong, I'm going from memory. This is a case where the complainant was told that their grandson was
That's correct.
in
That's right.
dire straits and that they needed someone to take their money. I'm sorry, they needed someone to withdraw money to save him from the dire straits that he was in.
That's correct. Your
All
Honor.
right. All right, state.
Judge, so what Mr. Mauer represented to the court is correct. There was a federal prosecution.
Excuse me just a second. All right, I can see you're pregnant, so there's no need to
I'm not trying to show
Okay.
that off.
All right, thank you. You may continue.
There was a federal prosecution that occurred out of San Diego, and the court is aware of the $1 million restitution that they were ordered to pay out of San Diego. I didn't have anything to indicate that this victim was included in that. However, this was a very big conspiracy that they put together where they were targeting elderly individuals. The victim in this case is 80 years old and was targeted because of that. Called and told that his grandson was in danger and that he needed to spend $12,000 immediately to provide safety to his grandson. And the $12,000 is agreed upon. The evidence did point back that it did go into this defendant's Chase bank account. And in the stipulated evidence, the records, the Chase Bank records are in there where the account is belonging to Anijah Gifford, Your Honor, and so, we would ask that you order the restitution if you do give her community supervision, but I just don't believe that she's a good candidate for community supervision. So we would ask that you deny the application.
All right. I'm not saying I'm gonna deny it or grant it, but when are you gonna have this $12,000?
If I'm being honest, I can't give a specific date, but I can make payments, whatever you order. If you order for me to make a specific payment, I can work on that.
All right, here's my question. Do you have any loved ones?
Yes.
Mom, dad? All right, let's assume that someone's picking up the phone and calling you and saying, hey, your mom has been in this accident and we're gonna arrest her unless $12,000 is paid, right? So look at that as that type of urgency. So when are you gonna have this 12,000? Because I can tell you, and your attorney can probably tell you, the person who's 80 years old and you scammed them out of $12,000, they're probably on a fixed income. They worked all their life to save that, and you came in because you didn't want to get a job and you wanted to build your happiness off somebody else's misery. So I want to know when you're going to have this $12,000, and I can tell you the latest is going to be in February.
I can do that.
I think that's a good idea, Judge.
All right. And I'm not saying I'm going to grant it, but what I'm saying, that would probably help your case tremendously because he needs his $12,000. So, Ms. Ferguson, recall this for sentencing in February, and you need to have the $12,000 and you need to be here in court.
I will be here.
All right.
I'll get her to sign a reset form.
All right. Thank you. We'll see you back on February 2nd. At that time, you need to come with $12,000. And state, does that need to be in cashier's check, money order?
And usually there's an upfront restitution form we have to fill out.
I can do that.
All right.
Yes, ma'am. Thank you.
You're welcome. And I'm sorry, Norm, you said February when? All right. Oh, and state, if I could see you and Mr. Mauer, please. Yes.
Okay, docket, it's for our hearing that we've got on Thursday for our Carla Phil. Oh, it's an Article 64 hearing
Mhm.
for DNA.
Mhm.
I emailed Norma a couple weeks ago about trying to make sure what time we're gonna do that.
1:30. They should be finished by this trial by then.
Okay, just double check because I didn't want to have my guys here at 9. And I'm sitting
No, I
around
mean,
here.
if you have
They're-
witnesses, they can appear by Zoom.
They're gonna come by Zoom.
Okay,
They're all
cool.
gonna come by Zoom, but they're gonna bill me by the hour while they're
Okay.
sitting there waiting.
Yeah, 1:30.
1:30. Thank you,
Exactly.
Judge. I appreciate
Well,
it.
you know what? Let's say 2,
You
just
too?
in case there are some issues. So 2.
2 o'clock.
Yes.
Thank you, Your Honor. Appreciate you.
You're welcome. Michael Mora? And Carlos, have you turned in your paperwork?
Yes, ma'am.
Has she been sworn in?
Yes.
All right. All right, if you could, thank you. It'll be after this one. All right, court is calling 2024 CR 4073, State versus Michael Joseph Mora. Can I have parties announced?
Lauren Espinoza for the state.
And Kelly Piddle from Stamore.
And are you Mr. Mora?
Yes, ma'am.
I don't know why this keeps doing this. All right, are y'all ready to proceed on the motion?
Yes, sir.
All right, Mr. Mora, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? I don't have a trial court certification.
Direct to continue.
I don't know if I'm going to follow that or not.
We do it while we're at.
Sure. All right, are you the same Michael Joseph Mora who was placed on community supervision in 2023 CR 4008 for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 to 200 grams on October 19, 2023? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 2 on or about the 8th day of February 2024 in Bexar County, Texas. The defendant, Michael Joseph Mora, did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
Violated condition number 2 on or about the 25th day of January 2024 in Bexar County, Texas. The defendant, Michael Joseph Mora, did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
State will waive the remaining.
Any objections to the state's waivers? Did you understand by pleading true to violations 2 and 2, the court could find it true, grant the motion, and sentence you to 5 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 2 and 2?
Yes, Your Honor.
Court will find violation of conditions 2 and 2 true. Is there a proposed agreement?
There is, Judge, the proposed agreement is to deny state's motion, alter and amend conditions to add mental health evaluation as well as follow those recommendations.
All right, and what is that based upon?
Based on the court summary here, there is notation from the probation officer that he may be struggling with that mental health as well as I believe defense would probably be able to speak to that better than the state.
Judge, we're in agreement with the state's recommendation. Mr. Moore suffers from mental health diagnosis, and we believe that he would be better served being supervised by the MIC unit and receiving treatment through probation.
If he's drug tested, if you're you want to raise your right hand for me, please? Do you solemnly swear affirm the testimony you yield will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Michael Mora.
Right. When you're drug tested today, what are the results going to be? And you are going to get drug tested today. I'm sorry.
Negative.
All right. What we're going to do is we're going to have you drug tested today, and I will make my ruling when you come back. Okay. Just 1 second. Still on the record, the court is finding violations of 2 and 2 true. Probation, would you send him to be drug tested?
Or no, is that he is prescribed Abilify.
Oh, he needs to tell them that.
Yeah.
All right. All right, thank you.
Thank you.
We'll see you back this afternoon.
What time?
When he finishes with his UA. Juliana Guzman. Thank you. If you'll come forward. Court is calling 2025 CR 006165 State versus Juliana Guzman. Can I have parties announced?
Carlos Martinez for the defense.
And are you Ms. Guzman?
Yes, Your Honor.
And for the state?
Lauren Espinoza for the state.
Counsel, you received all discovery. Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Ms. Guzman, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, I believe we are proceeding on counts 1 and 2.
That's correct.
Any objection to the waiver of count 3?
None, Your
Ms. Guzman, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, in count 1 and count 2, you're charged with assault of a peace officer or judge as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she is.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Guzman, has anyone threatened, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on counts 1 and 2. There's a $1,000 fine. State is recommending deferred adjudication. This will run concurrently with M210028CRB out of McMullen County. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
None, Your Honor.
Outside the agreement, the state is asking that your community supervision be for a term of 5 years. There be a TAP evaluation, 200 hours community service restitution, parenting classes, and mental health evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 1, how do you plead?
No contest.
Count 2,
No contest.
state any evidence.
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
Defense has no objections.
And state, have you had a chance to speak with the complainants?
Yes, Judge.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, are you ready to proceed with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, probably read on the police report, she called the police department because she was having an episode and she needed help with her infant daughter.
Mhm.
But, when the officers got there, they understood the situation, they handled it, in my opinion, correctly. What happened with my client is that she had 2 warrants out of another county. So the officers go, you know, we weren't really gonna do much today, but we gotta take you in because of those 2 warrants. So at that point, she goes, no, I can't, cause how about my baby, who's gonna take care of her and da da da. So that's how all this happened. But the officers were not really gonna proceed. But they was forced to because of the 2 warrants that she had from another county judge. So I would explain that to my client. I said, you have 2 warrants, they have the right to arrest.
All right, so this case from McMullen County, what is that about?
It's a charge for smuggling a person.
Hmm.
A person.
And she got five years, according to her, 5 years deferred. But she was ordered to go to some drug rehab program. And she's waiting a bit for that judge. But they wouldn't take her if she had something pending.
Oh, no, they will not.
Yeah, so that's why we're here.
And where is your child?
CPS as of right now.
Okay. All right, this is what the court will do. The court is going to run this concurrent with M210028 CRB. Regular reporting by Zoom or in person, regular random UAs, $1,000 fine that will be prorated. And probation, if you can find out if she's being, what inpatient program she's being sentenced to on that case, on the M210028 CRB.
What I've been told, Judge, just simple. I think it was.
All right, they're thinking it's safe P. So we'll do a TAP evaluation. But if you're all able to discover that it is safe P, then I will sentence her to safe P as well. Followed by continued outpatient treatment. Yes. The probation will contact you. They may not need to do another TAP evaluation if she's already been sentenced to safe P. We're just trying to discover that. There is going to be compliance with CPS. No unsupervised contact with minors. No residing in households with minors. If CPS decides that supervised contact is correct, or you can reside in the household, you need to come back here for a hearing on that. And when I do hearings on that, I require that somebody from CPS is either by Zoom or in persons. 5 years deferred adjudication. 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, 100 hours will be deemed satisfied. Probation, if CPS is requiring her to do parenting classes, which they should, then that can count for this case as well. And how far did you go in school?
I graduated in some colleges.
All right, so what are your plans for your career?
Chef. I want to go to culinary school.
All right, and if she completes, if she obtains her culinary certification, the remaining community service hours will be deemed satisfied. So you can make the decision, either you want to do that or you want to spend time in the Texas heat picking up trash. Probation is, there'll be field visits upon release. Until 1 time per month until further notice. Probation, is there anything else? All right, thank you. Proof of employment within 45 days of release, no employment as a home health care provider or with minors.
Understood.
Oh, didn't I say 5 years deferred?
Yes.
Yes, it's 5 years deferred. Probation, is there anything else?
She had said no, Judge.
Oh, she said no? All right, someone's talking to her. All right, did you review the trial court certification of Anything else, probation? All right. Anything else you need from the court to be successful? All right, here we go. Did you review the document titled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing, with CPS cases, you need to stay in contact with your CPS attorney. You need to follow through on everything that they're doing. On that side, you only have a year to complete things. And they will extend you, but they have to have good cause to extend you. So I'm sure that because you're going into inpatient treatment, they know that, but you're going to have to really work very hard. Otherwise, what's going to end up happening potentially is your child is going to be adopted out. And that may be with a relative or not. In this court, to be successful, communication is key. If there's an issue, let probation know about it. If you feel they're not addressing it, you can come back here. All right, good luck to you. Thank you.
May I be excused, Your Honor?
Yes,
Thank you very much.
you're welcome. Who's next? Let me see the MTR. Court is calling 2024 CR 3163 State versus Enrique Soriano. Who's the attorney? Could I have parties announced for the record?
Julie Pollock for Mr. Soriano.
Are you Mr. Soriano?
Yes, Judge.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Judge.
Are you the same Enrique Soriano who's placed on community supervision in 2024 CR 3163 for the offense of driving while intoxicated third or more on March 17, 2025 for a term of 4 years? Is that you?
Yes, Your Honor.
State?
Violation number 1, on or about the 11th day of April 2025 in Dare County, Texas, the defendant Enrique Soriano committed the offense of possession of pornography in violation number 1.
How do you plead to that? True or not true? All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4? I'm sorry, condition number 1.
Yes, Your Honor.
Court will find condition on number 1 true. Is there a proposed agreement?
The underlying 4 years.
Is that correct? Is that correct?
Really not an agreement,
Yeah.
but it's gonna happen.
All right, are you in agreement to revocation?
Yes.
All right, are you asking the court to revoke?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court is finding violation of condition number 1 true. The court will grant the motion, sentence you to 4 years in the prison. Give you credit for any time served. Court will recommend the therapeutic community. There's to be 2 years license suspension. There's to be no residing in households with minors. And no unsupervised contact with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, what is happening with the number 1?
He's already pled on that.
Okay.
We would ask that this case run concurrent with that.
What's
On a case number.
what is the cause number?
2025 CR 008253.
All right, state, do you have any objections to the cause numbers running concurrently? All right.
And just for the record, I was not his attorney on that case, so.
All right, this cause number will run concurrent with 2025 CR 008253. All right, thank you. Good luck to you.
Thank you, Judge.
Thank you, Judge.
Thank you. Thank you.
And you said there's a reset? Yes, I'm ready.
Page 6. Read through 5.
Jesse Martinez. All right, come forward. Good morning. All right, have you received all discovery?
No, ma'am, we're still working on that.
What's pending?
Your Honor, my understanding are the same records are pending. We did receive the CPS records and I have made those discoverable to defense.
Is saying the only thing that's,
At this point, yes, Judge. So again, I just was made aware that the records were made available today, so I have to take a look at that so I can do pretrial motions on it. I don't have any of the same records, and I don't know if there was some medical records as well that were outstanding. So we were working on that. Plus the state was amending the indictment as well. So I was waiting for that amendment.
when is the amendment going to take place?
Your Honor, at this time, I'm still deciding whether I'm going to amend the indictment. If anything, it would just be to combine the cases into one case that's already indicted.
All right, Ms. Ferguson, you all need to confer off docket. Set this for a plea deadline date at the beginning of February, please. All right, we're going to come back on February 3rd. That will be your plea deadline date. All right, do you have any questions, sir?
No.
All right, thank you.
Judge, appreciate it.
Nothing with you. I'm just saying hello.
Oh, hi, good morning.
How is everything?
Oh, everything is,
I want to be on.
no, everything is going well. I'll call you.
Okay.
Thank you so much for checking in, and I appreciate the continued prayers.
I've thought about it quite a bit.
All right, who's next? Natasha Manning. All right, so just have a seat. We'll have to bring you back at 1:30. All right, who's next?
Page 4, 6 down.
Jonathan Lee Pomerantz. Oh, just give me a. And then I'll call it break too. All right, so where are we?
I believe all discovery is now in, Your Honor, and have tendered an offer to defense.
We received the CPS records today, signed a protective order for those records, and received it.
All right, how old are you? All right, Norma, if you can set this for plea deadline date, mid-January, please. All right, at that time, you need to let me know whether or not you've reached an agreement with the state. If you have not at that time, it's going to be a quick turnaround for jury trial. All right, thank you.
Can I go back at 1:30 for Roland De La Garza?
Yes. All right, anyone else?
Page 9, down. Clarence, please.
Clarence Lacy. Where's Lacy? All right, so where are we on discovery?
We have discovery, Your Honor. We have an offer. We're asking for a plea deadline.
All right, Ms. Ferguson, on this, could you put this for the first week in January? January 8th.
Thank you.
All right, that will be your plea deadline date. There will be no further plea deadline dates. So on that date, you need to let the court know whether or not you've reached an agreement. All right, thank you. All right, we're on recess.